Legal and Privacy Brief for February 20, 2026. The Electronic Frontier Foundation published a formal governance policy restricting LLM-assisted code contributions to its open-source projects, establishing a disclosure and comprehension standard that sets a practical benchmark for AI code review obligations in security-sensitive environments. Austria's DSB and Germany's Regional Court of Hildesheim each issued new GDPR-related decisions, cases 2024-0, 199, 724 and 3026/24, respectively, continuing the EU's steady output of enforcement decisions and civil liability rulings under Articles 58 and 82. Amazon Ring terminated its data-sharing partnership with Flock Safety, a signal that surveillance tech vendor associations carry growing legal and reputational risk under state biometric and privacy statutes. Here's the full breakdown of today's top legal and privacy stories. Next section, Privacy Developments. DSB, Austria, 2024-0.199.724, Austria's Data Protection Authority, Datenschutzbehörde, DSB. Issued Decision 2024-0.199.724, ICLI. At DSB, 2024-2024.0.199.724, published on the Austrian Legal Information System RIS and indexed on GDPRUB. The DSB holds supervisory authority under GDPR Article 51 and regularly issues decisions on consent validity, data subject, rights responses, and lawfulness of processing claims. Austrian DSB enforcement has historically focused on inadequate consent mechanisms, failure to respond to data subject access requests within the Article 12 one-month deadline, and unlawful data transfers to third countries. The specific subject matter, parties, and penalty amount for this decision were not available in the collected source content at time of publication. The full decision text is accessible through RIS RIS. BKA, GV. At Compliance Action. Organizations with operations in Austria or processing data on Austrian residents should monitor the RIS database and GDPRUB's DSB category for the full decision text. If your organization receives DSA subject access requests from Austrian residents, verify your response workflows meet the Article 12.3 one-month deadline with the 2-month extension notice procedure documented in writing. Austrian DSB has shown willingness to issue reprimands and corrective orders on first findings. Source: GDPRUB 2024-0.199.724. LG Hildesheim 3026/24, Germany's Regional Court of Hildesheim, Landgericht Hildesheim, issued Civil Decision 3026/24, published in the Voris legal database. German regional courts handle private GDPR enforcement claims under Article 82, which provides data subjects a right to compensation for both material damages and non-material damages, including distress, loss of control over personal data, and reputational harm caused by GDPR violations. German courts have been among the most active in Europe on Article 82 non-material damages, with awards ranging from €100 for minor notice deficiencies to several thousand € for substantive violations, such as unauthorized disclosure or unlawful profiling. LG Hildesheim 3026/24 adds to this body of civil precedent. The specific parties, alleged violation, and damages amount were not included in the available source content at time of collection. Compliance Action. German market businesses should treat Article 82 civil exposure as a routine compliance risk, not just a regulatory enforcement risk. Conduct a privacy notice audit. Ensure notices state the correct legal basis for each processing purpose under Article 6, include all required Article 13/14 disclosures, and are written in plain language accessible to lay users. Maintain time-stamped records of privacy notice versions and user consent records. Even minor notice inaccuracies have resulted in German court awards. Documentation is your primary defense in civil claims. Source: GDP-RUB. US SRPL. US 11/2025-116, Slovak Constitutional Court. The Constitutional Court of the Slovak Republic, Ústavný súd Slovenskej republiky, issued decision PL. US 11/2025-116, which references Slovak Act 2026-13 published on EPI. SK. Constitutional Court challenges in Slovakia, filed under PL. UAQTES plenary jurisdiction. Address whether legislation complies with fundamental rights protections in the Slovak Constitution, including the Article 19, right to privacy and personal data protection. A successful constitutional challenge can suspend or annul legislative provisions. The case was filed in 2025 and resolved in early 2026. The decision's full text is available in Slovak on EPI, SK, and in summary on GDP-RUB. The specific nature of Act 2026-13 and whether the constitutional challenge succeeded were not extractable from the collected content. Compliance action. Organizations operating in Slovakia or processing Slovak citizens' data on behalf of public sector clients should obtain a translated summary of Act 2026-13 and the PL. UAQTES 11/2025-116 decision outcome. Constitutional rulings can void mandatory data retention or disclosure obligations, or conversely confirm them as constitutional, directly affecting what your organization must or may not do under Slovak law. Legal teams with EU cross-border exposure should flag this for local Slovak counsel review. Source: GDP-RUB. Next section, policy changes. Amazon Ring terminates data sharing partnership with Flock Safety. Amazon Ring canceled its partnership with Flock Safety, a surveillance technology company that sells automated license plate reader Alper networks to law enforcement agencies and private businesses. The termination is significant because it reflects how sustained public and advocacy pressure can fracture surveillance tech commercial relationships even between established players. Flock Safety markets its Alper systems to local police departments and HOAs, building bulk location databases from passive vehicle tracking. Ring's own law enforcement data sharing history, including its Neighbors app partnership program with police departments that drew congressional and FTC scrutiny, makes the decision notable. If Ring considers Flock's practices reputationally untenable, the surveillance tech market is recalibrating. The breakup signals that private sector surveillance partnerships now carry tangible legal and business risk, particularly as state biometric privacy statutes, Illinois BIPA, Texas QBI, Washington My Health My Data Act, expand to cover location and behavioral data in some contexts. Compliance action. Businesses that contract with third-party surveillance vendors for physical security, including Alper systems, smart camera networks, or facial recognition access control, should audit vendor data sharing agreements for law enforcement disclosure clauses. Confirm whether vendor contracts include provisions that could create downstream BIPA, CCPA, or Washington My Health, My Data Act exposure. Review whether vendor practices require your organization to provide notice to employees or visitors under state surveillance disclosure laws, e.g., New York City Local Law 144 for automated employment decisions, Illinois biometric notice requirements. Document the review. Source: Schneier on security. EFF publishes formal policy on LLM-assisted open-source contributions. The Electronic Frontier Foundation published a governance policy for LLM-assisted code contributions to its open-source projects. The policy stops short of a blanket ban, which EFF acknowledges is impractical given how pervasive AI coding tools have become, but establishes 3 requirements. 1. Contributors must fully understand all code they submit, regardless of how it was generated. 2. Comments and documentation must be authored by a human. And 3. Contributors must disclose any LLM assistance. EFF's rationale is operational and security-focused. LLM-generated code can replicate bugs at scale, is difficult to review with small maintainer teams, and introduces risks of hallucination, omission, and misrepresentation in security-sensitive codebases. The policy also acknowledges broader concerns around AI-generated code and copyright, though EFF notes it has separately concluded that extending copyright is an impractical solution to AI content issues. The policy is relevant to compliance programs beyond open-source participation. Organizations using AI coding assistants, GitHub Copilot, Cursor, Claude, Code Whisperer, in regulated environments, particularly those handling protected health information, payment card data, or personal data subject to GDPR or CCPA, face analogous risks. AI-generated data handling code may contain subtle privacy or security flaws that pass code review. EFF's Disclosure and Comprehension Standard provides a defensible policy framework that can be adapted for internal SDLC governance. Compliance action. Review your SDLC security policy for AI coding tool use. Require developers to document AI tool use for any code touching PII, authentication, encryption, or regulated data pipelines. Establish a review checklist specifically for AI-assisted code in security-sensitive components. Verify no hard-coded credentials, confirm correct data minimization, check that logging does not capture sensitive fields. Add AI tool disclosure to your vendor SDLC questionnaires if you assess third-party development shops. EFF's policy is publicly available as a reference template. Source: EFF Deeplinks. Next section: Compliance Takeaways. GDPR Article 82 civil liability is now a routine litigation risk in Germany. LG Hildesheim 3026/24 continues a pattern of German regional court awards for non-material GDPR damages. Conduct a privacy notice audit against Articles 13/14 requirements and ensure all consent records are time-stamped and retrievable. Even deficiencies courts characterize as minor have resulted in awards of 100-500 euro per claimant. In class action-style actions, exposure scales rapidly. Track Austrian DSB Decision 2024-0.199.724 on RIS for sector-specific enforcement signals. The DSB issues decisions across consent, data subject rights, and transfer compliance. Subscribe to GDP RUB's DSB category or set a Google alert for Datenschutzbehörde 2024-0.199.724 to catch the full published decision. If your organization operates in Austria, review your Article 12 response timelines now. Audit surveillance vendor contracts for law enforcement data sharing clauses before your next renewal. Ring's exit from the Flock partnership is a market signal that Alper and Smart surveillance partnerships carry escalating legal exposure. Review third-party security vendor agreements for provisions that could constitute third-party data sharing under CCPA or create BIPA disclosure obligations. Document the audit and any remediation in your vendor management program. Adopt an AI code disclosure and comprehension policy in your SDLC before a security incident forces one. EFF's policy provides a ready-made template. Require disclosure for any AI-assisted code touching PII, authentication, or regulated data systems. Pair disclosure with a mandatory human review checklist for AI-generated functions. SOC 2 and ISO 27001 auditors are increasingly asking about AI tool governance in development environments. Monitor Slovak Act 2026-13 and PL. UAQTES 11/2025-116 if you have EU cross-border operations. Constitutional decisions in EU member states can void or confirm mandatory data processing obligations with immediate effect. Engage local Slovak council to assess whether Act 2026-13 affects your data retention schedules, mandatory disclosure obligations, or legal basis documentation for Slovak data subjects. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.